General Varela, today you're arguing that the penalty is not a tax. Tomorrow you're going to be back and you'll be arguing that the penalty is a tax.
Former presidential candidate Congresswoman Michele Bachmann is one of the health care law's most outspoken critics. She will be at the hearings tomorrow. She is also a practiced tax attorney. Michele Bachmann, Congresswoman, welcome. Good to have you here as always.
Good morning. Good morning, Martha.
Boil this down for everybody at home in terms of what happened yesterday with regard to this issue of a tax and what it revealed to us about how the justices are thinking so far.
Well, yesterday was very important because depending on how yesterday went, that would indicate whether the justice would continue going and take up the all-important issue of the individual mandate today. And then on Wednesday, they'll take up the issue of severability, and they'll also take up the spending clause. There's really 4 issues that the judges are looking at. But the very first one is this case even ripe to come before the Supreme Court? And it hinges on this issue of whether or not the penalty that an individual American would pay for failing to buy health insurance is actually a penalty or a tax. And so it seemed yesterday during the course of the hearings that most of the justices, including the liberal judges, were thinking that this would be considered a penalty, which means the court can hear the case. Off from the 18th century, or actually from the 19th century, that says that if a matter is a tax, a lawsuit can't be filed before a court because government can't be stopped from collecting a tax until it's actually put into effect.
All right, so it seems as if they've gotten past that point, and now they're on to this issue of the mandate in today's proceedings. We were listening to a piece that Shannon Bream did earlier, and she spoke to one of the attorneys who was, in favor of continuing to uphold this health care law, and he said that he sees no problem with the commerce law in this case. He said whenever you have commerce that represents 1/6 of the U.S. economy, it is ridiculous in his mind, that's my word, but that was the sentiment that he expressed, to suggest that the Congress cannot oversee that process for 1/6 of the U.S. economy.
Well, that's a pretty radical view because if a person adopts that view, that means that Congress can regulate any activity, whether we have activity or don't have activity. That's really the nub here because Congress is attempting to regulate inactivity. And so, in other words, Congress could force us to do anything. If we're going to purchase a car, they could force us to buy an electric car that we don't want. If we don't have a gym membership, they could force us to buy a gym membership. That's absurd. At that point, we no longer have a constitutional republic. We have a dictatorship, and that's not what America is.